This is Chapter 1, Criminal Justice Today. The objectives we're going to cover in this chapter are as follows. First, we will describe the two most common models of how society determines which acts are criminal. We will explain the two main purposes of the criminal justice system, outline the three levels of law enforcement, list the essential elements of the correction system, explain the difference between the formal and informal criminal justice processes, define ethics and describe the role that it plays in discretionary decision making. We will contrast the crime control and due process models, and finally list the major issues in criminal justice today. What is crime? A crime is considered to be an act that violates criminal law and is punishable by criminal sanctions. Determining criminal behavior is what we're going to talk about now. And it's not always an easy task to determine what is or what defines criminal behavior. Different countries have different ideas of criminal behavior. But there are two common models of how society in general decides which acts are criminal. First is the consensus model. This assumes that as people gather together to form a society, its members naturally come to a basic agreement regarding shared norms and values. It assumes to a certain extent that a diverse group of people can have similar morals. The conflict model assumes that different segments of society, separated by social class, income, age, and race, inevitably have different value systems and shared norms, and are engaged in a constant struggle with one another for control of society. What is deemed criminal activity is determined by whichever group happens to be holding power at any given time. An integrated definition of crime, considering both the consensus and conflict model, constructs a definition of crime in that it is any action or activity that includes the following. It is punishable under criminal law as determined by the majority of society, or in some cases, a powerful minority. It is considered an offense against society as a whole and is prosecuted by public officials. It is punishable by statutorily defined sanctions that bring about a loss of freedom. And then there are differences between crime and deviance. Deviance is behavior that is considered to go against the norms of established society, and deviance is a subjective concept. Deviant acts become crimes only when a majority is willing to accept that those acts should be punished. Not all crimes are considered particularly deviant. Criminal law reflects acts that a society agrees are so unacceptable that steps must be taken to prevent them from occurring. So here are a couple of discussion questions for you to consider based on just a little bit we've gone through so far. Take these questions and consider them. First, are there any criminal statutes in your community that prohibit behavior that you do not believe is deviant? Second, are there any deviant acts committed in your community that you believe should be criminalized? The criminal justice system is an interlocking network of law enforcement agencies, courts, and corrections institutions. It is designed to enforce criminal laws and protect society from criminal behavior. The purpose of the criminal justice system is manyfold. First, it is to protect society from potential future crimes of the most dangerous offenders, to determine when an offense has been committed and then provide the appropriate punishment. It is also to help rehabilitate those who have been punished so that it is safe to return them to the community. And then finally, to support crime victims and return them to their pre-crime status. To understand the structure of the criminal justice system, it is important to understand the concept of federalism. First, law enforcement and local law enforcement duties are split between counties and municipalities. The chief law enforcement officer of the county is the sheriff. It is an elected post, generally from a 2 to 4 year term. The bulk of local police officers are employed by municipalities. Their job is to investigate crimes, attempt to deter crime, apprehend criminals, and participate in trial proceedings, and they're charged with keeping the peace. State law enforcement is important too. However, it is important to note that Hawaii is the only state without a state law enforcement agency. There are two general types of state law enforcement agencies: state police and highway patrols. Other state law enforcers include fire marshals and fish, game, and watercraft wardens. Then there is federal law enforcement, which is made up of the Federal Bureau of Investigations, FBI, the Drug Enforcement Administration, DEA, and the U.S. Secret Service, the Bureau of Alcohol, Tobacco, and Firearms, ATF. So, under the concept of federalism, federalism is a form of government in which a written constitution provides for a division of powers between a central government and several regional governments. And there are three main institutions that make up the criminal justice system, just to remind you that we mentioned before: law enforcement, courts, and corrections. Now let's talk about the importance of federalism. Federalism means that government powers are shared by the national or federal government and the states. The division of powers allows states to create their own police power, enacting whatever laws are necessary. So with local law enforcement, it's split between counties and municipalities. At the state level, just to remind you again, that includes state police and highway patrols, and state law enforcement can also include fire marshals. And federal operate throughout the U.S. and work in cooperation with local and state counterparts. Now, this slide shows just how many employees work in the system and which jurisdiction they work for. So you have local, state, and federal employees in our criminal justice system, and it's broken down into law enforcement, judicial and legal, corrections, and then there's a total on the far right. Please become familiar with this slide. Now let's talk about the courts. The court's dual court system with two independent judicial systems operate on the federal level and the state level. There are 52 different court systems, one for each of the 50 states. Trial courts operate at the local and state levels. The intermediate courts are the appeals courts or the appellate courts, and then you have state supreme courts. And then there is one federal court system. You've heard of federal judges. Those are the ones that operate on the federal court system. You have district courts, circuit courts of appeal, and the United States Supreme Court. There is one court for the District of Columbia system by itself because it is not a state. That's why there are 52. Well, there are 50 different state court systems. There's one for the District of Columbia, and then you have the federal court system. The criminal court has a work group made up of judges, prosecutors, and defense attorneys. They are responsible for determining the innocence or guilt of a suspect, obviously with the input of a jury. A couple of more discussion questions for you to consider. First, what are the advantages of moving to a unified court system and eliminating the dual court system? The next discussion question for you to consider is, what are the disadvantages of a unified court system in the United States? Now let's talk about corrections. Offenders may be placed on probation, incarcerated, or transferred to a community-based corrections facility once they've been delegated to the corrections system by the court. Probation is the most common correctional treatment, allowing the offender to return to the community under supervision. Incarceration may include jails or prisons. Jails house offenders that are convicted of minor crimes with relatively short sentences, whereas prisons house offenders convicted of more serious crimes with longer sentences. Community-based corrections include halfway houses, residential centers, and work release centers. The most frequent type of release from jail or prison, again, is parole. The criminal justice process debate about whether or not the system functions as a quote-unquote continuum which smoothly processes cases is an ongoing discussion. The criminal justice process functions as a continuing balance between its formal and informal nature. The formal criminal justice process involves a series of routinized operations whose success is gauged by their tendency to pass along a successful conclusion. In the informal criminal justice process, each step is the result of decisions that must be made by those who work in the system. There is a model called Herbert Packer's criminal justice process. You need to read about this in your book. But he compared the idealized criminal justice process to that of an assembly line, and it relates to the formal criminal justice system. Let's talk a little more in depth about formal versus informal criminal justice. In the formal criminal justice, it's a series of routinized operations. The goal of moving the defendant from one point to another is actually the ultimate goal. The decisions are made within the rigid confines of formal rules and laws, but it's unrealistic. It lacks the resources to handle every case formally. The informal criminal justice system is made up of decisions based on personal judgment, which produces an informal criminal justice system. It does not operate within the rigid confines of formal rules and laws. The informal criminal justice system relies on discretion. Discretion is the authority for the court to choose between and among alternative courses of action, and it's based on individual judgment and conscience. An example of that is when you hear judges pass down sentences and a judge in a neighboring county might pass down a different type of sentence for a very similar crime or infraction. And that is a good example of the informal criminal justice system at work, where these two judges made decisions based on their individual judgment and conscience as to the punishment that should be handed down to a person in each of those two counties. Here are a couple of more discussion questions for you. This would be a good idea to get together with fellow students and role play and discuss the following situations that lend themselves to discretion, like I was just talking about. Here's the first scenario. You are on routine patrol and you pursue a car that is traveling 80 miles per hour that runs through a red light. You pull the car over and discover that the driver is your boyfriend or girlfriend's mother. What do you do? The second scenario, you are a police detective who has just arrested a person for aggravated domestic violence. You see that your partner is punching the suspect in the face when the suspect is handcuffed and in the back of a patrol car. What do you do there? Again, consider these questions on your own, but if you can get together with a few of your fellow classmates and discuss these, it will bring a lot more expansive vision to the discussion. Now let's talk about ethics and justice. The line between ethics and justice is often difficult for anyone to discern, as ethical standards are not usually written into criminal statutes. There's a saying that you cannot legislate ethics and morals, and this idea is where that comes from. So very often ethics and morals are not specifically written into law, but their intent is. As far as ethics and critical thinking goes, the principle of critical thinking involves developing analytical skills and reasoning to address many ethical challenges that are inherent in the criminal justice system. Because ethical standards are not written into criminal statutes, individuals often have to fill in the blank. And what that means is that is where a judge, for instance, might make a ruling based on the intent of a law rather than the specifics of a law, because ethics and morals are not written verbatim into laws. Then it's up to a judge, or sometimes an appellate court, or even the Supreme Court at the state or federal level, to determine what was the spirit of the law and how does it apply in this individual case. And again, just to remind you, as far as ethics and critical thinking are concerned, critical thinking involves developing those analytical skills and reasoning to address ethical challenges that are inherent in the criminal justice system. And what that means also is that laws are not black and white. They're subject to interpretation. And critical thinking is what allows fair and subjective interpretation. Now, there are two models of criminal justice. First is crime control model, and the most important function of the criminal justice system is to punish and repress criminal conduct. The criminal justice system should function quickly and efficiently as an assembly line. The due process model has its focus on protecting the rights of the accused through legal constraints on police, courts, and corrections. It strives to make it more difficult to prove guilt, and fairness, not efficiency, is the goal of the due process model. So on this slide, you see the crime control model on the left, and the goal of it, which is to determine crime by arresting and incarcerating criminals as quickly and efficiently as possible, and the methods used. And then on the right side of the slide, you see the due process model, which has its goal to protect individuals charged with a crime against the immense and sometimes possibly unjust power of the state, and the methods used to achieve the due process model. Please make sure you review this. Here's another discussion question for you. Which model of criminal justice, crime control, or due process is utilized today in your community? What specific elements of law enforcement informed your choice? Now we're going to talk about criminal justice today. With crime and law enforcement, there are core concerns. One is smarter policing, where evidence-based practices should be in play. They involve proactive policing that promotes more rigorous enforcement of minor offenses, hotspot policing that focuses on high crime rate areas rather than spreading resources evenly throughout a metropolitan area, and identifying criminals. For instance, DNA profiling allows law enforcement agents to identify a suspect. There is increased use of biometrics as every day goes by right now. There are continuing challenges with gun violence, where you have mass shootings or an incident in which 4 or more people, not including the shooter, are killed and wounded. And there were more than 1 a day in the United States in 2015. The internet has increased awareness of this. And then continuing with gun control, proponents call for expanded background checks, whereas opponents don't believe background checks will help. With police and use of force, there is now what's called the video's glare, or the glare of the video camera, and what has become known as a Ferguson effect. This was a national debate kicked off after the death of Michael Brown in Ferguson, Missouri. This theory of a chilling effect on officers who fear being labeled as racist is what has become known as the Ferguson effect. With video and excessive force, that calls into question police credibility, and the use of body-worn cameras, the impact of this is still unclear. And then there are ongoing issues of trust and race, where negative media attention may have decreased public support of law enforcement, and racial contention exists with minority communities. There is a new element that's come into criminal justice in the past 20 years, especially after 9/11, and that is domestic terrorism and homeland security. This involves protecting the homeland, in other words, our nation domestically. And part of the phenomenon that we're trying to protect ourselves from is the crowdsourcing of terrorism. And what that means is, for instance, how ISIS recruits online. And then there's also the issue of security versus privacy in trying to monitor crowdsourcing for domestic terrorism activities, like white nationalists, for instance. They're in trying to monitor those activities versus personal activity. There's a lot of debate about how we maintain security and protect privacy. As far as prison population trends, for the first time in 4 decades, incarceration rates are not rising. There are about 2.2 million people that are in prison, and about 4.7 million people are under community supervision, in other words, parole or halfway house, etc. There is a movement that has taken shape in recent years called the de-incarceration movement, and also a justice reinvestment, which is policies that redirect funds saved by lowering a state's inmate population into strategies that improve community safety. Federal and state correction systems are attempting to keep nonviolent offenders out of prison and release good prisoners early. Then there's also a diversion, which are special drug courts, with release and reentry programs that offer treatment for nonviolent offenders. There's also a declining use of the death penalty. At the end of 2015, there were 3,000 people on death row, down from 3,653 in 2000. The Supreme Court of the United States barred execution of people with intellectual disabilities, juvenile offenders, and those convicted of crimes other than murder. There are 7 states that have abolished the death penalty altogether. In terms of incarceration and race, African Americans make up only 13% of the general population in the United States, but the number of black men in state and federal prisons is significantly larger than the number of white men. And Hispanics inmates ratio has increased dramatically over the past decade as well. So those are definitely areas of focus. Even though there's a de-incarceration movement, there's an additional sub-focus of minority unjust persecution. As far as justice in crime and punishing juveniles, because juveniles are more susceptible to immature and irresponsible behavior than adults, they should not have to face the death penalty. A reconsideration of 2,500 juvenile inmates serving life without parole sentences is an ongoing process. The question is whether or not, as they mature into adults, their behavior will then modify as their brains mature, and can they be rehabilitated during those formative years as well. As far as the role of victims right advocates are opposed to policy changes. Widespread recognition began in the 1970s. Because incarceration involves physical, emotional, and financial consequences. Then there is also the incidence of wrongful convictions. There have been court reversals based on DNA evidence of overturning convictions, and there is sometimes the human error or misconduct that affects fairness and impartiality as well. Class, that is all for Chapter 1. If you need any clarification or if you have any questions, please be sure to contact your instructor. Make sure that you go go back and consider the discussion questions. And remember that this presentation is a supplement to your text. Your text should be your primary source of information. And the slides that we looked at, the tables that we looked at that came from your chapter are in chapter 1. Make sure you go back and look at those in detail. Again, thank you for your time. We'll meet again for chapter 2.